Hey, and welcome to the Intellect.Business YouTube channel. I am here today for that Intellect Boss Talk. I thought it was very important to create an area just specified for business. So that's what we're doing today, talking business. And business is a very broad topic. So, specifically today, we're talking about ownership. And everybody nowadays talking about how they want to be a boss. Okay. Everybody got boss behavior and boss mentality now. But really, at the core, what is being a boss? Being a boss is ownership. And today, I wanted to break down the differences between some ways that you could create and then own your intellectual property. So, you may be asking, what is intellectual property? Intellectual property is anything that you are uniquely creating um, for the purpose of distribution. And really, this could be anything because for us to be living in this moment, somebody had to create these things, right? If we're talking about art, if we're talking about words, books, we're talking about furniture, like all of these things have been created from nothing. So, how do you create that ownership? Through patents, copyright, and trademarks. And today I've got a really great book here for us. It is Nolo Law. I this this where the facts are. When you're a business person, you got to find reliable resources. And Nolo is a very reliable resource. There are lawyers who come together to print factual information, and the topics range from everywhere. So you can get books, boss books about anything with Nolo, and it's reputable. Okay. So first and foremost, we are going to talk about patents. So when we're talking about ownership, creation, patents are they come in three different types. Most recognized is the utility design patent, or excuse me, the utility patent. They have the design patent, and then also there is a plant patent as well. Um, with patents, this is someone creating something, and then once they have created it, they are able to patent it and then license it to other people to utilize and use. So, some of the ways that you would utilize these patents would be through a company can hold the license. A license may be exclusive, it could be non exclusive. A license could be sublease. It's just so many options. But ultimately, the patents are the utility patent, which could be one of five categories. It could be a process, a machine, a manufacturer, a composition of matter, or improvement of an existing idea. So that would be a utility patent. And most of the time, that's what we are referencing when we talk about patents. But designs can also be, design patents can be new and original designs. That ornament and manufacturer article can qualify for a design patent. So, for example, a new shape of a car, a bottle, a flashlight. So, really kind of overall, kind of upgrading something that is already in existence. And then finally, a plant patent, which is it's the least frequented type of patent, but it is granted for any asexual or sexually reproduced plants, such as flowers, that are both novel and non-obvious. So overall, what to be provided with this patent, you have to demonstrate how to make and use the invention, explain why the invention is different from all the previous or even similarly designed items, and then finally prescribe precisely describe what aspects of the invention deserve a patent. So that's number one, a patent. Okay, number two is copyright. You hear people talking about copywriting all the time. So what is a copyright? It's a variety of original expressions, including art, sculpture, literature, music, songs, choreography, poetry, software, music, video games, website. I mean, whatever somebody can be uniquely created, it can be copyrighted. I mean, first, it must be original. It must be fixed in a tangible, concrete medium of expression. So, like they even said, art, the art would need to be placed in some kind of format for it to be um, a mode of expression. All right. Because the idea couldn't be copyrighted because it's the mode of expression hasn't been expressed yet. It's just in here. That's why you got to get it out. Next, it must have some creativity. And creativity and uniqueness, all of that is what we're talking about. So it has to have that as well. So the copyright does not protect the idea or facts, it only protects the unique way in which the idea and fact is expressed. So it's the form of expression that is being copyrighted itself. So loved that as well. Um, Also, with copyright, it's best to copyright non-published works all at the same time because you can do it up to 10 of unpublished works can be copyrighted at once versus if you publish the work, then you have to do it individually. So that is something as well. When you are copywriting, the best way for someone to copyright would it can be in different routes. It could be a person singularly creating something to have it copyrighted, or it can be done as work for hire. So if you're working under a business, uh, as an employee, if you are working as a contractor, if you are working under a pseudonym, those are also things that would be considered working separate from a person, more as an entity. So if you are copywriting through your individual self, then it will last for 70 years. But if you are copywriting through a business or work for hire or a pseudonym, it would be 95 to 120 years. So that's also, that's facts right there. And one of the benefits as to why you should copyright your work. Also, what happens if there's infringement? Infringement means that somebody is trying to get your work. That means that it will be you could order an issue, you could be awarded money and damages in certain circumstances as well. So there are benefits to making sure that you legalize and create that intellectual property. Finally, we're going to talk about trademarks. Trademark law consists of legal rules by which a business protects their name, logos, other commercial significant signifiers used to identify their products and services. So these can be a wide range of things. It could be words, it could be phrases, it could be images, it could be designs, anything that is specific to a particular business and how they've been branding their business. It needs to be created uniquely, whatever this thing that would needs to be trademarked would be. It could be words, common words and phrases, and words that cleverly connote qualities about the product. So, like suggestive marks, terms that attempt to literally describe it, surnames, and geographic names. So, it is such a wide range of things that can be trademarked and what areas as well. Trademark really is just signifying how your business is unique and different. Okay, so what there are things that will not be able to be trademarked, things that are non-use, things that are generic, which confusingly similar words, weak marks, and functional features. Those things cannot be trademarks because of the fact that it's not solidifying how you and your business have intricately woven the fact that this belongs to you. All right. So I just wanted to tap in today to give you the difference between those three things. Again, I am reading from this Nolo, patent, copyright, and trademark. But I just wanted to provide some insight to everybody because, as we're on our journey to being bosses, to be a real boss, it comes with knowledge, understanding, wisdom, being open, and learning new things. So, hopefully, today I was able to shed some light for you in regards to patent, copyright, and trademarks. And really hoping that you all visit my website, www.intellect.business, just to check it out, see what resources there are there, and click around this YouTube channel, see what you learn, leave a comment. Thank you so much. I appreciate you. Many blessings and positive vibes. Peace.